This is Counterpoint, and I'm your host, Tanya Granic Allen. Today, we're going to turn to an issue that has triggered both legal debate and deep concern among many Canadians: your right to defend your home and property, especially when faced with an intruder. Recently, in Lindsay, Ontario, a homeowner awoke in the early hours to find someone inside his apartment. The intruder allegedly broke in, was armed with a crossbow, and the ensuing altercation left the intruder with life threatening injuries. The homeowner has now been charged with aggravated assault and assault with a weapon. The intruder himself is facing break and enter charges. But it's a case that raises the urgent question: when does self defense become a crime? This incident comes at a time when public anxiety is surging. A recent poll found that over half of Canadians no longer feel safe in their neighborhoods. Many fear for the safety of their families and homes, and some are beginning to ask, is if the justice system can't guarantee our safety, what can we do ourselves, and how far can we go before we're the ones facing the charges? So, should Canadians have the right to defend their homes with force, perhaps even deadly force, when faced with an armed intruder? Where exactly is the line between justified self defense and criminal liability? And are current laws keeping pace with the growing concern and real risk Canadians face? Well, joining me now to help unpack all of this is Robb Macdonald, a seasoned criminal defense lawyer with over 20 years of courtroom experience. Robb has represented a wide range of clients, self defense, property defense cases across Ontario, and is frequently consulted on matters of legal reform and civil liberties. We're also joined by Tristin, who's a journalist with the National Post and has written on this topic amongst as well as several other topics. Robb, Tristin, thank you both for being here. I appreciate your time.
Thank you. Thank you for us.
Okay, so maybe we'll actually start with you, Tristin, before we get into some of the legal nuts and bolts. But let's start with the Lindsay case, because this one I think shocked Canadians, maybe the world. What happened there, and what is being reported, and what's going on?
We haven't gotten, as is typical in a lot of these cases, we've actually received very few details from the police. So all we know is basically what you described. And then when there was pushback, including from Ontario Premier Doug Ford, you had the police service in that instance releasing a statement, again very light on details, saying that, oh, this will come out in a court of law. Trust us, we know what we're doing. Stop criticizing the police. Implying that they know things that we don't, which has happened in cases. So in the story I wrote about this, there's been other instances in which someone who is defending their home is hit with charges of aggravated assault, or in some cases second-degree murder, and it won't be till months afterwards that those charges are dropped by Crown prosecutors, because prosecutors have figured out there's no way they can succeed at trial. So in the interim period, the person who defended their home is no longer facing criminal charges, but they've emptied out their bank accounts and gone through unbelievable periods of stress in the interim. Sometimes have been under strict bail conditions in that time. So that's sort of where the homeowner in this case is as we speak.
Okay, so Robb, from a legal standpoint, what are the key elements that determine whether or not the actions of the homeowner, excuse me, would fall under legal self-defense? Because again, Tristan's correct, we know very few details. I appreciate that they won't necessarily be forthcoming because we're not the jury, we're not the judge. We just want our laws enforced. So what would likely have happened here, or what's the determination whether this was self-defense or not?
Well, I think we have to start with the grounds that police officers have in laying a charge. So the police officer has to be convinced to the standard of having reasonable and probable grounds to believe that a crime has been committed to then lay a charge. So they don't have to believe beyond a reasonable doubt that a crime has been committed, or even necessarily that the prosecutors will succeed in the prosecution. So that's the first issue. And then the
So
second
just
issue.
let me just ask you on that. So the it is up to the police officer at the scene to determine whether they're going to proceed with charges or not. They are at that moment the adjudicator of what has gone on the scene.
That's right. And the police officer, this is the grounds have to be objectively justifiable, and they have to be beyond mere suspicion that a crime has been committed, but it's less than believing a crime has been committed on a balance of probabilities. So it's the terminology that is required is that they have reasonable and probable grounds to believe that a crime has been committed.
Okay, I'm going to pause you there. We're going to take this up just a few moments.